now request my colleague Mansi to kindly introduce our co-speaker. It is now my privilege to introduce our distinguished speaker, Shri Vishwajeet Sawant, sir, senior advocate. Sir is a distinguished member of Bombay Bar with over 3 decades of experience, a graduate of St. Xavier's College and Government Law College, Mumbai. He enrolled as an advocate in 1990. Over the years, he has appeared in wide spectrum of matters before the Bombay High Court, including commercial, constitutional, arbitration, and custom land matters. Designated as senior advocate in 2020, Mr. Sawant has also served as an arbitrator in numerous constructions matters, bringing to the field the invaluable perspective of both counsel and arbitrator. Ladies and gentlemen, please join me in extending a warm, respectful welcome to Shri Vishwajeet Sawant, sir. Thank you. Ladies and gentlemen, the practice of arbitration demands more than a change of forum. It demands a change of mindset. The true art of an arbitrator, advocate, lies not in transplanting the courtroom into tribunal, but in understanding that arbitration demands a different temperature, a different temperament, a different discipline, and often a different vocabulary of advocacy. An arbitration is not a civil suit conducted in different court or a different room. It's a distinct process with its own philosophy, its discipline, and its own culture. One often hears experienced arbitrator observe that some advocates walk into the arbitration determined to conduct a full-fledged civil trial, only to discover that tribunal has no such intent. Today's session promises to show us how an arbitration is truly meant to be conducted. With great respect, I request Honorable Justice Riyaz Chagla to kindly assume the conduct of proceedings. I will then request our co-speaker, Vishwajeet Sawant sir, to kindly come and address the gathering.
Right now what I'm going to do is just give you an overview of how today's session, the three of us will proceed. Justice Farhan Dubash will first talk about how lawyers should prepare for an arbitration and what are the responsibilities of a lawyer while appearing during an arbitration proceeding. He will also discuss about how juniors can participate in the process of recording examination and how they can contribute to it. When I take up, I will speak about experts' evidence or experts' reports and how they can be utilized in the course of arbitration. Justice Riyaz Chagla will deal with the topic about approaches in commercial disputes as departed from the civil suits, and he will also talk about difference in arbitration and suit proceedings. And of course, we will at the end of the session leave some time for question and answers, and we'll also deal with more general topics such as how arbitration process can be improved, and I think Justice Chagla will also deal with that. So this is generally the manner in which today's this session is expected to proceed, and I will now request Mr. Justice Dubash to address you.
Thanks, Vishwajeet. Good afternoon, everybody. Normally, in an event, this is the worst session for a speaker because we expect that the lunch has been good, as a result of which, in order to keep you interested and, dare I say, awake, our session has to be a little more interesting than others' sessions. So we'll try our level best to make this session interesting, to keep everybody engaged and therefore awake. When Suresh Sabrat came and spoke to me that Avi is planning to conduct this session and where I would like to speak, I naturally said yes, because arbitration is one of my favorite subjects, and it was, dare I say, one of my core practices when I was a lawyer. Initially, as a lawyer arguing before a tribunal, and then in the last 10 years before elevation, I took on a lot of matters as a member of the tribunal, both a sole arbitration tribunal as well as a member of a two-member, three-member tribunal. Not a two-member, three-member tribunal. So the topic that I have chosen to speak and address you on today is something which, for a lot of juniors and for a lot of people who otherwise may not be very familiar with arbitration, how to prepare yourself whilst conducting an arbitration. The first thing that one should keep in mind, and when I'm observing people in the audience, I see a lot of junior advocates who would not only be advocate on record, but would also act as and appear as counsels in an arbitration. So I will talk to you all from both angles, that if you are an advocate on record and you were to engage a counsel, vis-a-vis you are a counsel who is actually appearing in a matter. Now, the first and the most important difference, according to me, between an arbitration and a court litigation or a court suit, if I were to categorize it, I would say that a court matter is like a sprint, whereas an arbitration is like a long distance race that you run. Now, the question that will come in everybody's head is, why do you say that? Because arbitration is supposed to be a speedy remedy, whereas court is supposed to take a lot of time. I say this because normally as counsel, when you get a brief to appear in court, your brief is either to appear for an interim or an ad interim, to ask for or to oppose, or your brief is final hearing. So your brief is specific to a particular stage of the proceedings, unlike an arbitration. Because in an arbitration, most briefs that are given from the start till the end. Or at least that's my belief, that when you brief a counsel or when a counsel is briefed in an arbitration, the same counsel has to continue throughout. And I'll tell you why. So that is why I say that in an arbitration, it's like a long distance vis-a-vis a court, where your only job is to appear and either obtain a relief on a particular day or to oppose a relief for a particular day. Once your job is done, you mark your brief, roll it up and send it back. In an arbitration, if you get a brief, your job is to start thinking as to what is going to happen today, depending on what stage you are briefed, until how are you going to argue the matter. Now, if you are an advocate on record and you have an arbitration brief, let's say an arbitrator or a tribunal is not yet appointed. Your job as an advocate, a very important job, is to choose the right tribunal. If you go to an institutional arbitration, then of course you have a panel which is already chosen. You have guidance in the form of a write-up on each member of the tribunal that you can opt for depending on which institution you choose to go to. But in an ad hoc arbitration, with all due respect, you may have a situation where, for a particular matter, a practicing lawyer may be a better arbitrator as compared to a retired judge. Again, it's all specific to the matter. So therefore, as an arbitrator, if you get a matter and you have the option to recommend names for arbitrators, your first job is to understand what the matter is and then accordingly choose or recommend, because very often you may not be in a position as one side lawyer to choose who the arbitrator will be. Your job will be to recommend 3 names or 4 names. The other side will recommend 2 names, 3 names. And if a name is a common name, then that person gets picked. Or then the court appoints. When the court appoints also, the court will ask, do you have any suggestions? And at that point in time, you need to be prepared. You should not just give the first name that comes to your mind, or the last retired judge from the court who has retired, so therefore you give something. So you're expected to do a little bit of research into the area of practice of the arbitrator who you're going to choose, as to whether that person is the right arbitrator for your particular matter. So that is one very important thing which everybody has to keep in mind. And also, another important thing whilst choosing an arbitrator is also to understand how busy he is. Because sometimes, very often, you have very good arbitrators, but you find that they are heavily engaged, as a result of which, if your one's hearing is today, the next hearing cannot be lesser than 3 months, because they have so much of work. So if that is a consideration that you need to keep into account, then that is also something that should be there at the back of your mind whilst you're choosing your arbitrator. Because otherwise you will land up with an arbitrator after you appoint him, only to learn that, look, the arbitrator's diary for the next 4 months is completely blocked. Whereas your client says, no, I want to ensure that I have an urgent 17 application which I want heard and decided in the next 2 months. But then the arbitrator you've chosen says, sorry, I can't give you anything for the next 4 months. Then it's embarrassing then to ask for a replacement. So you have to ensure that all this homework you do before choosing or recommending somebody's name as an arbitrator. So this is qua an advocate who appoints an arbitrator. Now, from an attorney's point of view, when an attorney looks to appoint a counsel for the purposes of conducting the matter, how do you choose the counsel? My firm belief is that the best counsel in court may not necessarily be the best counsel in an arbitration. The reason being that in arbitration, I firmly believe that one needs to be thoroughly prepared with the brief. One needs to know the brief inside out. And if the counsel is busy with court work, it's a challenge for him to devote the amount of time that an arbitration matter requires, and therefore to be prepared. So therefore, when you're choosing a counsel, please be conscious of the diary of the counsel. Please be conscious of whether the counsel takes up arbitration during court hours or the counsel takes up arbitration after court hours, because that's another topic which I will come to also. So it wouldn't hurt to ask a counsel before you appoint him or her as to what that person's approach towards arbitration is. But your decision has to be informed, because otherwise you may have a counsel after you appoint who says, sorry, I don't do arbitrations in the day, I can only do it post-court. The arbitrator turns around and says, sorry, I will not do arbitrations post-court, I will only do the arbitration between 11 and 5. Then you're stuck. You don't know what to do, to change the arbitrator or to change the counsel. So these are things that as an advocate you need to be aware of, and you need to put that into motion so that your arbitration proceedings go smoothly. Also, when you get a matter as a lawyer and you're appointing a counsel, you need to be able to assess and see whether the brief requires a junior counsel and a senior counsel or only one counsel, and what the level of standing of that counsel should be. Because not all matters really require a senior. Not all matters also require a senior junior. You may have so many arbitration matters where even a 5-year-old junior can conduct it beautifully. So you should be in a position to know the matter, read the matter, and then accordingly appoint the lawyer who you want to appoint. Now, once your appointment is over, appointment of lawyer, appointment of arbitrator, the next step that follows is the drafting. Drafting of the statement of claim and drafting of the statement of defense, the two pleadings. Here, I feel that most times importance is not given to pleadings, and drafting is done because of timelines, the pressure of timelines. Drafting is done just to ensure that a draft is prepared and filed within the prescribed timelines. Unlike a suit, I don't think very many of us have had the privilege of drafting a plaint and ultimately arguing the plaint that you have drafted. There will be very few lawyers who have actually drafted a plaint and finally argued that particular suit. But in an arbitration, that is more common. And according to me, that is the right practice. Because if at the stage of drafting, the counsel or the lawyer knows that he is going to be the one who's finally going to be arguing that matter, take it from me, he will pay a lot more attention to that particular draft than a draft that he would when the suit is to be filed in court. Because I was also a lawyer for lots of years, and at some point in time, your drafts, when you prepare your drafts, you don't envisage yourself arguing it. Whereas in an arbitration, once you know that you are going to be arguing the matter, you are going to be asking for the reliefs that you have drafted, including 10 crores of damages for loss of all these, as in the claims that people put in arbitration, reputation, harassment, etc. Then drafting is done more responsibly. So therefore, I would recommend that when a counsel or an advocate is appointed for the purposes of drafting, that counsel should be told that you will be the one who will be taking this matter all the way through, and that would actually make that lawyer or that counsel work a lot harder in ensuring that draft is a draft in which he would be comfortable arguing. Because now we all know that costs that an arbitrator awards are actual costs. And I would like to see a day where in a plaint or in a statement of claim, if you have 5 prayers, this is again my view, if you have 5 prayers, if you succeed in 2 and you fail in 3, but the 3 that you fail in, out of that 2 of those prayers, you don't even argue, you give up at the stage of final hearing. I would like such a party to, as in costs to be imposed against such a party. Why? Because you have drafted 2 prayers, as a result of which the other side has had to defend those 2 prayers. Other side has to lead evidence to defend those two prayers. Considerable time has gone, money has been spent, only for you at final hearing to say, okay, I know I'm not going to get this. You don't say that I'm not going to get this, but okay, I'm going to give up this prayer. And you seem magnanimous that, all right, I'm giving up this prayer so that the arbitrator is then happy. Arbitrator should not be happy. Arbitrator should, in fact, be upset that if you are giving up this prayer, why did you include this prayer in your statement of claim in the first place? And you should be penalized for that. That is my belief. And that is how costs have to be imposed. And it is only when this practice actually gets ingrained in all of us will we find responsible pleadings and parties conducting arbitration proceedings responsibly. Again, giving up of a prayer happens when you have a counsel who comes at the stage of final hearing and then realizes, what sort of a prayer have you drafted? What sort of evidence is there? Nothing is there. So rather than me arguing and making a fool of myself, let me just give it up. Whereas if the counsel continues from start to finish, this would not have happened. So therefore, please draft responsibly when you make statement of claim. When you are seeking damages, please ensure, if your client says make a claim for 10 crores, you have to ask him why 10 crores, why not 1 crore? And ask him at the stage of drafting that, okay, if he says 1 crore, what is the document that he has to support that claim for 1 crore? So as a good draftsman, when you draft a claim, you have to be prima facie satisfied at the stage of drafting that there is some material which if accepted is going to be able to satisfy the claim for 1 crores. Because we all know it. You can actually count it on your fingers, the amount of matters in which damages or a claim like this for loss of reputation, for goodwill, those are just made to be given up. Nobody argues these at final hearing. They are just there to fill up the last 3 prayer clauses in your statement of claim. So somebody should be responsible, and it's high time that we start. These practices are not there in international arbitrations. In international arbitrations, even your claim for loss of goodwill is supported with documentary evidence. Oral evidence sometimes is also led. So why not over here? Why should this practice not be followed in India? And because of this practice or this trend that is happening for the last so many years, no award actually has ever awarded damages for loss of goodwill, reputation, etc. It's about time. If drafting is done responsibly, evidence is given in support, and if you succeed, there's no reason as to why you should not get a claim like this. But all of that starts from drafting. So, drafting from statement of claim, drafting statement of defense. Next, we come to the hearing before the tribunal. Normally, once pleadings are drafted, the tribunal, or actually before pleadings are drafted, nowadays tribunals have a case management or the first hearing, etc. But I would recommend, as I'm going to tell you, to defer that case management hearing for some time. You should not have a case management hearing at the very first hearing and decide the timeline saying, okay, you will take 4 weeks for SOC, you will take 4 weeks for SOD, and then we will meet for issues, etc. You should do your case management after pleadings are complete, and I'll tell you why. After pleadings are complete, the next step is points for determination or issues, as we all know it. What happens in points for determination and issues? That is a stage where both parties know each other's case. Both parties know which points they are likely to succeed, which points they may not be in a position to succeed. They would also be in a position to then gauge for which point they would need to lead evidence. Whether that evidence has to be oral, whether that evidence has to be documentary. Issues are then framed or settled by the tribunal. It is only after issues are settled, according to me, would parties be in the correct position to actually determine what evidence and how much evidence they are going to require to succeed, either to succeed in their case or succeed in their defense, whichever way it is. There is a practice that is there in our city, in our country, that for every issue, for every dispute, people want to lead oral evidence. Not all disputes require oral evidence. You should be confident as a lawyer to say that this particular dispute can be settled by written document. If there is a contract which is required to be interpreted, you should have I can't say strength, but you should have that much of confidence in the drafting of the contract to say that I don't need oral evidence to prove what is in writing. It is a written document. I am interpreting it in a particular manner. The other side is interpreting it in a particular manner. There is no oral evidence that is required to be led in a matter like that to say why my interpretation is better than his. Because ultimately, you are not going to succeed on oral interpretation of that contract. So parties need to be confident at that time that yes, I would be in a position to prove this particular issue only on the basis of documents. Now that requires confidence not only on your part, but equally it requires confidence on the other party, on your opponent. Because so often it happens where as one party you go in and say, okay, I don't want to lead evidence, but if he's leading evidence, then I will be put at a disadvantage. In that case, even I want to lead evidence. So this is something which both parties have to go into an arbitration. Because at the end of the day, everybody should remember that the reason why client has chosen the forum of arbitration is for expediency of the matter. Parties don't want to wait 20 years that a suit would take in court. Parties want their dispute to be resolved in a particular timeline. And as lawyers, as stakeholders in an arbitration, whether you're the tribunal, whether you're the AOR, or whether you're the arguing counsel, everybody has to have a little amount of responsibility to ensure that that motive is achieved at the end of the day. So, both parties, according to me, owe it not only to themselves but also to our profession to ensure that where oral evidence is not required, they should be confident enough to say that yes, oral evidence is not required, and we will go ahead and determine maybe not the entire matter, but at least one issue or two issues without leading oral evidence, only on the basis of documents. It is only after settlement of issues that both sides can then evaluate what evidence is required to be led. If it is documents, then the documents by that stage already would be ready with you. There's nothing that you need to do. If it is oral, then you need to know as to whether that particular issue requires the evidence of one witness or maybe sometimes more than one witness. Normally, if a particular fact has to be proved, my recommendation and recommendation of various seniors also would be always have one witness prove one fact. Never have multiple witnesses giving the same testimony, because that only gives rise to a problem during cross-examination when one of the two witnesses says something which is inconsistent. So you have to ensure that, and law does not say that if you have two witnesses saying the same thing, then the tribunal will accept it better than if one person is saying it. So, after issues are settled, you would be in a position to know that yes, I need to lead evidence in order to prove 1, 2, 3, 4 points. Point number 5, 6 documents are enough. So therefore, in all, I will need 2 witnesses. You will then know how much evidence is required, whether your evidence affidavit is going to be 4 pages or 40 pages. It should not be 40 pages, but what the size of your evidence affidavit would be. And according to me, at that stage, parties should have a proper case management hearing again for trial. Because one of the main drawbacks, and I've experienced it personally, to arbitration is the unchecked cross-examination that is done in arbitration, in ad hoc arbitrations. I don't know if how many of you have had the occasion of appearing in a foreign arbitration or an institutionalized arbitration process, but for those of you who have, you will know that you have a time-bound process for cross-examination, which means that they will tell you that you have 2 hours, you have 4 hours to conduct your cross-examination of 4 witnesses. Now, whether you choose to use all 4 hours on one witness, or you break it up into 2 hours, 1 hour, half an hour, that's your choice. But 4 hours is all that I'm going to give you. That is what is determined by the tribunal. And that is what I am saying should also be followed in ad hoc arbitrations over here. And this can only happen if the case management hearing takes place after issues, so that parties know. And to that matter, even the tribunal will then realize that what sort of evidence is required to be led. In ad hoc arbitrations, unfortunately, I should say that, lawyers ask questions endlessly, starting from the standard question of what are your educational qualifications, what is your work experience, how many matters did you do, how many contracts have you done, all sorts of questions. These are preliminary or introductory questions, as we would call them. And in that bargain, the first 5, 10, 15, sometimes even more, are used up in that. In an international arbitration, take it from me, I have not seen anybody ask that question. All of that is either set out in the evidence affidavit, because the witness has to depose as to what his qualifications are, etc. If he is not, then as a cross-examiner, why are you bringing his qualifications on record if he himself has not done it? And whatever his qualifications are, it's irrelevant to the matter in hand. Because at the end of the day, he may be a PhD, but if he can't answer the question on the fact that he is giving evidence on, it's of no consequence. So, a lot of people prepare questions. Even I was guilty at one point in time, preparing questions, saying that, okay, I have a session from 5 o'clock to 7 o'clock tomorrow. Let me prepare today. So I would say that, all right, judging by the manner in which the witness had answered on the last occasion, I think I'll prepare 25 questions for tomorrow. So I'll prepare 25 questions for tomorrow and go at 5 o'clock today and tomorrow in the evening, and 25 questions are over. Initially, that's the way that a lot of people, including myself, would conduct. But gradually, as I grew into the practice, I realized that that was a wrong way of going about. Because all that I was doing in that is only filling up that one day. When you sit to prepare for cross-examining a witness, you have to prepare yourself on day one for the entire evidence affidavit. Because you don't know that in your question that you ask on day one, if the witness gives you an answer which is on a topic that you've not yet read and therefore not yet prepared for, which you will in the next session or the session after that. If you were prepared, you could have cross-examined him immediately on that point today itself. But if you are not ready for the entire evidence affidavit, you would not be in a position to know whether the answer that he's given, that where he strayed off the point, if he strays off the point, is right, wrong, or to what extent he is right or wrong. So therefore, my request to everybody who prepares for cross-examination is please ensure that you are ready on the first day for the entire evidence affidavit. Also, when you prepare for cross-examination, like I have been told or I was told by various seniors, you have to prepare that what if the witness gives an answer which is not the answer that you are looking for. So, if you want the witness to say he was present at a particular place when the event happened, that's the answer you're looking for. But you have to be ready with a question, with a follow-up, if he says, no, I was not present. So whenever you're preparing yourself, always be ready if the witness goes off track. What are you going to ask him for him to come back on track? Not every paragraph, every sentence in every paragraph is required to be cross-examined. We have a fallacy where people sit with the evidence affidavit and literally underline sentences. And on every sentence, they will frame one question at least, because otherwise they say, oh, I have not controverted him on that question, on that particular sentence. Every sentence in an affidavit of evidence does not need to be controverted, because the witness is saying the truth. You don't have to controvert him on everything that he says. So when you are preparing for cross-examination, the key is to identify those particular areas or those particular portions of his testimony which according to you is incorrect. That's one scope or one part of your cross-examination. And the other part of your examination is, whilst you're doing that, try and get him to admit some of your case or some of the evidence which you want to lead. As a result of which, at final hearing, you would be in a position to tell the arbitrator that, look, not only has my witness affirmed what I am saying, but even in cross-examination, the other side's witnesses affirmed it. So you have to be prepared to see that by judging the scope of the knowledge of the particular witness as to the topic that you can cross-examine him on and get him to say. Your cross-examination need not be restricted to the evidence affidavit. His evidence affidavit is only what he wants to say on a particular matter. His cross-examination, your cross-examination is on his knowledge about the matter, whether it is stated in the evidence affidavit or it is not. If you are in a position to establish that he has knowledge, he is entitled to be cross-examined. He will naturally not say something that's going against him. So therefore, as a cross-examiner, it's your job to get him to give you that answer. So that's the role, or that's the exercise that you undertake when you do cross-examination. Now, one more thing that I want to tell everybody, and again, this is from my personal experience. A couple of years ago, I did an arbitration using a transcription service. I won't name the service because there are quite a few and I'm not here to recommend one over the other. But what is a transcription service? A transcription service is a service which records what is being spoken in real time. So if there was a transcription service being run as we speak, it would be flashing on the screen everything that I am saying now, so you don't not only hear what I am saying, but you can also read what I am saying. If I cough, it will actually say cough, cough. It goes to that extent. This service is commonly used in international arbitrations. Until a couple of years ago, it was not freely available in India. Very few people companies actually were giving that sort of service. But now I'm told there are a lot of people who give that service. It's still a little expensive, but I would say in the long run, it is a lot cheaper to the client. And I'll explain why. How much does the client pay for every hearing? Starting from venue, to the arbitrator, to the lawyers, to the counsel, to administrative fees, if you hire a stenographer, to stenographer charges. So you total up and you'll come to a figure of, say, a couple of lakhs if it's a reasonable arbitration. If there are two counsel, then obviously your fees go higher. If you have a designated senior, then the fees go even higher. These transcription services, I think, or at least when I checked last, that was about 2 years ago, they were charging somewhere in the region of about 80,000 or about 1 lakh of rupees a day. As against 1 lakh of rupees a day meaning say 11 to 5, so you would have 2 sessions. If you don't have the transcription service, you would have a stenographer. The stenographer for 2 sessions maybe would charge 10,000 or 15,000, maybe 20,000. So you're paying 80,000 rupees more per day. But normally, and I tell you this from experience because I've done arbitrations for the last 15 years. Normally, in a 2-hour session, very rarely would you ever go more than 50 questions. As against that, whilst using transcription services, ordinarily, on an average, you do 150 questions in a 2-hour session. Ordinarily. You can even go faster. I am saying ordinarily. So, 3 sessions into 1. Correct? So, for the 80,000 rupees that you are spending more on the transcription services, you are saving 2 session fees of all the stakeholders who are participating in that arbitration. That's a huge amount as far as the client is concerned. What it also does is, and I found that from my personal experience, what it also does is, it puts a greater sense of responsibility on the counsel who is the cross-examiner to ask the right questions and to be prepared. Because otherwise what happens in a cross-examination is that you ask a question, the witness does not hear it or does not understand it, you repeat it, and that process keeps going on. He gives an answer, then he realizes, no, I have chosen a wrong word, I want to change that one word. Then he says, no, I didn't say yes, I actually meant no. Correct? You have so often, and then you enter into a dialogue with the arbitrator saying whether I said yes, whether I said no. Finally now, what is your answer? The arbitrator will say. Now imagine, all of this is happening live. So, the witness is seeing what his first answer is. The witness is then seeing him say, no, I did not say this. I actually meant something else. As a result of that, even witnesses then are on their guard to ensure that at the very first instance they give the right answer. They ensure that they don't change their answer, because in an ad hoc arbitration, most of us, even as an arbitrator, I would permit the witness before the next question is asked, you can change your answer, you can delete one sentence, you can delete one or two words, etc., as long as your answer is not inconsistent with what your earlier answer was. None of this happens when a transcription service is used, because the entire exercise is transcribed. And when you use a transcription services, the arbitration, the rules, as in everybody agrees that there will be no deletion. So you can't delete anything. Another benefit that you get, so often there is chit-chat, not only between lawyers, advocates, witness, but also general chit-chat. When there is transcription on, there is no chit-chat. For 2 hours, everybody who is present in that room only does what they are supposed to do. At the end of the day, the only person who succeeds is arbitration and the client. So my request is that in future, I would like to see more and more people using these transcription services, because they will only better the process of arbitration. Because 150 questions need to be asked in a session, lawyers are more prepared. Because even the witness knows, so even the witness gets prepared. The witness is then not given a chance to say, oh, I will check and come back tomorrow. In a matter like that, the arbitrator has to tell the witness, look, you have given deposition, notwithstanding the fact that your deposition is in respect of an event that is 20 years old. You have to familiarize yourself with your testimony when you come for cross-examination. And we are not going to give you an opportunity to come back tomorrow after refreshing your memory from records. So whatever refreshing that you need to do, you ensure that is done earlier, and then you come for cross-examination. So not only does the lawyer more prepared and responsible, but even clients or even witnesses are that way more prepared. And I was telling people that in an international arbitration, what happens is that, and I have done it myself, international arbitrations from start to finish get done sometimes as in a short period of 10 days. You normally have sessions which go on for the entire week. So I have had matters where you have Monday to Friday, 11 o'clock to 5 o'clock, is the session for cross-examination. 5 days broken up again after case management. The 3 days will be for the claimant and 2 days will be for the respondent, or whichever way that parties may agree upon. Then you have a gap. Again, the gap is not an abnormally long gap. The gap is of a couple of weeks to prepare yourself. And then you have 5 days of final hearing, start to finish. No session today, then people checking the diaries as to when the next session will be, etc. If this practice gets incorporated into our ad hoc arbitrations, I truly believe that that is when the actual purpose of arbitration will be served, and that is when people will again have the faith in the arbitral process as it's deserved to be. Also, this transcription service, I hope I'm Vishwajeet, am I okay on the time or am I talking for too much? Okay, I'll end in 2 minutes, and then if I have some. I had told them that if I keep going on, they should interrupt me. I would recommend that the transcription service also be used at final hearing. Why? Because very often you have a situation where there is a dispute that whether this was argued or whether this was not argued. You also have a situation where lawyers say that, okay, please give me 5 days to give you written submissions. Correct. 5 days doesn't happen. They always ask for 2 weeks of more than that sometimes, and then the extension, etc. If you have transcription, You don't require those 2 days, you don't require 2 weeks, you don't require anything. What you argued, you have a transcription at the end of the day. The arbitrator uses that transcription. This is what you argued, this is what I will consider for the purposes of my award. There's no need for finding, as in submissions, etc. What you argue is there on record. So therefore, I would say that transcription should also be used at final hearing, which will, at the end of the day, speed up arbitration as it is supposed to be. Sorry, I think I've extended my stay. So in case there is more time at the end, I will touch up on something else. Thank you very much.
I was to remind Justice Dubash if he exceeded his time. But the fact is that even I got engaged in listening to him, so I could not stop him. When he spoke about the time when you select your arbitrator and your counsels, note one thing, that at that time you must also consider who is going to be your arbitrator in terms of not just an ex-judge and not just a senior advocate or an advocate, but there is also a body of arbitrators who are experts in a field. They play a big role in conducting an arbitration and the carriage of an arbitration proceeding. In my recent experience when I was attending an arbitration week in January, there was a session held where there were a lot of advocates from all over, and then there were experts in their individual fields. Experts who are engineering experts, experts who are accountancy experts in intellectual property rights, so on and so forth, architects, design experts. The debate in that session was, and in fact they took a vote at the end of it, should an expert be an arbitrator or should a lawyer be an arbitrator? Though this session had majority lawyers, the vote was in favor of an expert. Of course, the theme of that session was more relating to construction contracts. In a construction contract, trust me, an expert plays a major role. A, if he is an arbitrator, and B, even in assisting the lawyers during the course of an arbitration. And lastly, when he appears or he is called by one of the parties to give evidence as an expert on a point in issue. It plays a big role in arbitrations relating to constructions because there are very specified rules governing constructions. There are designs involved. In intellectual property rights, though it may not be possible to decide who is the owner of a proprietary mark, but there are sub-rights, for example, licensing of a mark, etc., and claims based on that. Those can also be subjected to experts in the IT field. Then there are accounts. There are in contracts which are given for construction, let's say. Invariably, there are delays in execution of works. And one party blames the other party for the continuation of delays. In a case like this, many times either the arbitrator himself is an expert or the arbitrator chooses to appoint an expert to evaluate the claims and give a report by evaluating the delays which have been caused and by which party. And on the basis of this, it plays a big role because there are huge amounts of damages which are claimed. And this becomes a very important part. Prior to the Arbitration Act, especially the 1996 Act modified by 2015 Act, expert evidence was governed in suits by Section 45, where a civil court could call an expert opinion on, let's say, foreign laws or experts' opinion in fields in which they had special knowledge, skills, etc. The Arbitration Act in Section 26 makes a specific provision under which, notwithstanding the party autonomy, and it doesn't give up party autonomy because it says, unless otherwise agreed by the parties, the tribunal can appoint or call for an expert report from a person on a specific issue which he thinks is necessary for decision in an arbitration. Similar leeway is given to a party to appoint an arbitrator. So there are two methods in doing this. A, there is a party nominated expert and a party can bring forth his report and file it as evidence. Or there is an arbitrator appointed expert. When the arbitrator appoints the expert, a party can call upon the expert who is filing his report to produce all the documents, all the materials, all the information that has been gathered by him, so that the party is aware of what is the material used against him, and the party also gets the right to cross-examine. So the party can compel such a person giving a report, an expert giving a report to the tribunal, to attend the arbitration proceedings so that the party can cross-examine and question the expert who has given the report on the basis of whatever information is available. If a party has nominated an expert, similarly the other side party also gets the opportunity to cross-examine the other side's witness or put up its own witness. The expert's report, when it is called for by an arbitrator, is not binding on the arbitrator. And of course, the arbitrator cannot delegate his essential function, which is of adjudication of disputes. So no doubt this is not a report which is binding on him. But it does carry a persuasive value. Now this happens, and just as Farhan Dubash pointed out to you, it makes immense sense to decide right from the beginning how your arbitration is going to go. And that also includes whether you should be appointing your arbitrator who is an expert in the field, or are you going to engage an arbitration. Now that is a pre-arbitration decision you have to take. Are you going to engage an expert to guide you through the claims and also guide you through what are the nature of claims and the amount of damages that you are going to bring home, or you'll be able to bring home in order to get those kind of amounts. So when you engage an expert right in the beginning, you know your strengths, you know your weaknesses, you know your pitfalls. And that helps you to channelize the course of arbitration and bring home an award with ease. If you fail to do that, and if you say, in a given case, you're arguing a construction contract or an architectural design contract before another advocate who has absolutely no inkling of what goes into designing, in that case, you have to explain to the arbitrator, firstly, you should be aware of all the nuances of the contract, all the designs, all the requirements, whichever are the measurements to be used, whichever the formulae to be used, etc. Secondly, you should be able to communicate that to the arbiter. This becomes easy when you are able to, when you are able to engage an expert to guide you through, or you appoint an arbitrator who's already an expert. As a result of this, the arbitrator would go through the entire material that is placed before him, and he is able to appreciate your case in a much faster manner. In my experience, in fact, in MES contracts, that's the military engineering services contracts, they are all ex-MES people who are appointed as arbitrators. And they just do quick calculations and tell you, yes, this is the amount of claim which should be granted and which should not be granted. So it's much easier. Sometimes those arbitrations get over once your pleadings are over in one session, because it's a matter of calculation. Produce the measurement books. This is the amount which is recorded. This is the rate to be applied. And this is the amount which you will be entitled in your final bill. You will get this or you will not get this. This is what is decided. When an expert is brought before a tribunal, remember one thing, that with the assistance of another expert, you must also be able to be ready to cross-examine such an expert. No doubt, Justice Dubash has also mentioned to you, you don't start with what are your qualifications, etc., etc. But you must know your witness very well. If you have information about any, let me say, a prior publication by that very witness, which is contrary to the evidence which he is giving, you can certainly use that against him for discrediting his evidence as well as his report. His report stays binding. It becomes evidence only after he steps into the box and he allows himself to be cross-examined. So the role of an expert in an arbitration, and I'm going to be a little brief about this, is not to be undermined. But remember, given the kind of arbitration that you're doing, if it's a mere contractual disputes which does not require an expert, obviously you're not going to get one. But if such an expert is required, you must make the effort of at least consulting the expert to guide you through the arbitration and the statement of claim and the evidences that you must be putting forth in the arbitration. The expert is not to do a job of investigation, but has to give a very fair, independent assessment of what are the claims made in the arbitration, and also assess the areas of dispute and give his findings and evaluation based on the material which is faced by him. Equally, there are disclosures which are required to be made by an expert, which includes, in a case where an tribunal appoints him, what is the material which he has relied upon? If he has spoken to anybody, what was that information that he gathered? In a case in Hong Kong, in fact, you won't believe, one expert who was appointed actually went on to act like an investigator. He went and interviewed a party and recorded the conversation without the other party knowing. The appellant in that case challenged his report and said that this was done behind my back, and that report was set aside. In fact, the arbitral tribunal, the award also was set aside because it proceeded by accepting that report. An expert is not an investigator. He has to do his job of evaluating the claims and informing the arbitrator whether such a claim can stand or it cannot stand, and what may be the measure of damages that may be granted. So, we normally deal with arbitrations which do not require, unless there are, of course, construction contracts and heavy architectural contracts, etc. There, I would say, whenever you start with an arbitration, please go ahead and consult an expert. Keep him engaged all throughout your arbitration proceedings. It will take your proceedings to the end. It will bring you home an award, and a favorable award for that matter. With this, I understand there are time constraints and I need to No, that's okay. So I'm going to now invite Justice Chagla to address you on the further things.
Well, as Mr. Sawant has introduced us and what we are going to speak about, I would just like to say that my discussion is going to be on how there has been a departure of the rigid procedural trials in civil suits when it comes to arbitration. Well, in arbitration, it's left really to the arbitrator to determine procedure. Unlike the CPC, which governs the procedure so far as civil suits are concerned, and to a lesser extent, where commercial suits, which are under the Commercial Courts Act 2015 are concerned, where fortunately for not only the judges but also the counsel and litigants, suits have been made to proceed in a much speedier manner, and the procedure by amendments in the CPC, so far as commercial suits are concerned, have in fact reduced the time in which commercial suits are disposed of. Arbitrations as such are governed by the Arbitration Act 1996. The law has evolved. The arbitration law has evolved. First was the earlier law in 1940. Now 1996, there have been further amendments. But what one needs to particularly take notice of is Section 19 of the Arbitration Act, which expressly provides that the arbitral tribunal shall not be bound by the Code of Civil Procedure 1908 or the Indian Evidence Act 1872, now the Bharatiya Sakshya Adhinayam 2023. This is perhaps the single greatest departure from traditional trial. The arbitral tribunal possesses wide procedural discretion, subject only to fairness, equality, and natural justice. Section 18 of the Arbitration Act ensures equal treatment and full opportunity to present one's case, and arbitration rejects procedural rigidity but not procedural fairness. One must always bear that in mind. Now, the other provisions, such as Section 24 of the Arbitration Act, provides that the arbitral tribunal shall, as far as possible, hold oral hearings for the presentation of evidence or for oral argument on day-to-day basis, and not grant any adjournments unless sufficient cause is made out, and may impose costs, including exemplary costs, on the party seeking adjournment without any sufficient cause. Notice of hearing is to be given well in advance, and all documents are to be communicated to the parties. The Section 26 of the Arbitration Act empowers the arbitral tribunal, as Mr. Sawant has addressed, Mr. Vishwajeet Sawant, to appoint one or more experts to report on specific issues. And Section 27 provides for the court's assistance in taking evidence. Judicial assistance is available only where necessary for evidence, and the tribunal itself remains the primary adjudicator. The departure from the traditional trial approach can be seen in the arbitral process, where the arbitral proceedings proceed efficiently and is characterized by party autonomy procedural flexibility, and efficiency. As I had referred to the commercial suits, the Commercial Courts Act has also endeavored to streamline the adjudication of commercial disputes through stricter timelines and case management proceedings before the commercial courts, but they are still governed by the CPC as amended. Arbitration, by contrast, permits the parties and the arbitral tribunal to adopt the procedure best suited to the dispute, subject to, as I had adverted to earlier, principles of fairness, equal treatment, and natural justice. The departures are therefore evident at every stage of the proceedings, from the conduct of hearings and taking of evidence to the making of the arbitral award. What is most important to bear in mind is the party autonomy. Whereas civil trial is a procedure prescribed by statute, arbitration procedure is determined primarily by agreement of the parties. The arbitrator is a creature of the contract between the parties. Now, coming to documents before oral evidence, unlike the traditional civil trials, modern arbitration is predominantly document-driven. Documentary evidence, as my brother Judge Justice Farhan Dubash had highlighted, forms the foundation of the proceedings, with oral evidence generally being limited to the examination and cross-examination of witnesses where necessary. It's important to bear in mind where necessary. As Farhan had pointed out, usually when one identifies a case which can be determined through documents, then one should not needlessly go into the oral evidence, because that saves the time of everyone concerned, including in disposing of the arbitral proceedings. Now, consequently, many domestic and international commercial arbitrations are substantially decided on the basis of documentary evidence, written witness statements, and expert reports. The witness statements replace examination in chief. The tribunal-led process actively manages proceedings through procedural conferences, timetables, and procedural directions. There is a strict case management, which, as my earlier speakers had pointed out, should be after the issues are framed, because then one knows exactly how to proceed with the arbitration. This proactive approach enables a tribunal to streamline the proceedings, address procedural issues at an early stage, and ensure the efficient and expeditious conduct of arbitration. Thus, there is a relaxed evidentiary regime. As pointed out, the Evidence Act does not strictly apply. Tribunals, though, may draw guidance from well-established evidentiary principles relating to relevance, admissibility, burden of proof, and appreciation of evidence, but more importantly, exercising their procedural discretion. There is also an element of confidentiality in arbitral proceedings. Court proceedings are generally public. Arbitration proceedings remain private. They are generally, the access to arbitral proceedings is ordinarily restricted to parties unless disclosure is required by law or for enforcement of the award. Confidentiality enhances the commercial confidence. The earlier sessions would have, you must have heard the earlier sessions and eminent speakers there, where there's a limited judicial intervention so far as arbitral awards are concerned. And so far as evidence is concerned, it has been laid down in the judgments of the Supreme Court, in Associate Builders, Sangyong Engineering, and PR Shah Shares and Stockbrokers, where the Supreme Court has repeatedly held that the arbitrator is the sole justice of the quality and quantity of evidence. And the courts have consistently emphasized that where the arbitrator adopts a possible view based on evidence, judicial interference is impermissible merely because another view is equally plausible. This principle distinguishes arbitration from other civil proceedings where the appellate court steps in and routinely reassesses factual findings. There is also a limited power now which has been laid down by the Supreme Court in Gayatri Balasamy versus ISG Novosoft Technologies Limited, 2025 INSC 605, to modify arbitral awards in narrowly defined situations rather than invariably setting them aside. And the law, so far as patent illegality and perversity, has now been laid down in several judgments of the Supreme Court, that these are the only factors where really the court should step in and set aside the arbitral awards. This has been laid down in Delhi Metro Rail Corporation Limited versus Delhi Airport Metro Service Express Private Limited, 2024 SEC Online, SC 522. There are certain drawbacks insofar as arbitration proceedings and the trials conducted, which one must try and take care of by the arbitrators, especially in ad hoc arbitrations, following in the procedure adopted in international arbitrations, as my brother Judge Justice Farhan Dubash had mentioned. There is the major reason for delay in the arbitral proceedings is the persistence of litigation-oriented mindset. Advocates often import practices followed in civil courts into arbitral proceedings by filing lengthy pleadings, raising hyper-technical objections, and insisting upon extensive oral evidence, seeking repeated adjournments, and filing routine procedural applications. Arbitration is in fact intended to be a flexible commercial process and not a private civil suit. Due to the paucity of time, I would like to end by referring to the comment made by the Chief Justice of India, the Honorable Chief Justice of India, Justice Suryakant, in the 4th International Conference of the Indian Council of Arbitration, where he observed that arbitration was becoming the disease it was meant to cure. And of course, there have been amendments, and we do hope that there would be an endeavor to see that arbitration proceeds in a manner as it is an alternate dispute redressal, that it proceeds in a manner where the speed is an essential requirement, so that arbitrations such as international arbitrations, what my brother Judge Justice Farhan Dubash pointed out, should be properly case managed, and it should be an endeavor should be made that the time limit should be strictly adhered to. The evidence should be proceeded in a manner where there is, of course, transcription, where in fact the time is saved in such transcription, and then ultimately one can have that the litigant who goes for arbitration has the confidence that the arbitral proceedings would come to an end in a very short time frame, and that the courts would be reluctant, because I have also been a judge hearing arbitration matters, reluctant to interfere in awards unless there's patent illegality or perversity. This should be borne in mind in order to cure the deficiencies which are right now in ad hoc arbitrations, and a lot can be learned from international arbitrations to that extent. Thank you very much.
Ladies and gentlemen, we now open the floor for questions. Volunteers, please be there with the mic. There is a time constraint. I'm requesting strictly question, not for you, sir, but for others. Strictly questions only, please.
Just one question. How proactive or passive an arbitrator should be in an arbitration, if any of you all can throw some light on that? Because is an arbitrator expected to be proactive or just passive throughout the arbitration?
Mr. Mehta, also.
I think
You need to speak into that.
it's on. Is it on?
Yeah, he चालू करा.
Yeah, it's on.
Mr. Mehta, so far as that is concerned, it's very important for the arbitrator, as you are aware, like international arbitrations, that they should read the proceedings before starting the arbitration. They should familiarize themselves with the matter so that they frame the issues in a very structured manner. Case management is also very important, and strict timelines to be adhered to so that the arbitration is promptly over in a very short manner. That's what's required.
In fact, if I may just say, we had one arbitration in which the arbitrator was very emphatic in saying that these are the points of dispute, these are the areas of evidence I expect from the parties, and nothing beyond that. Now, this happened obviously because the arbitrator herself had completely read the matter, had gone through what were the possible dispute areas. In fact, she had identified the dispute areas. And both the parties did agree, yes, these are the disputed areas, and evidence was confined only to that. So there was no long drawn evidence over a period of a month and going again, adjournments which go after 2 months, etc. This was all completed in a week or 10 days. And that's all the end of evidence.
If I can also just add my 2 bits. According to me, that is what is expected of an arbitrator. An arbitrator is somebody who's chosen by the parties. That means that he has their faith and confidence. To do what? To do justice. So if justice requires him to stop a cross-examination because he feels that the cross-examination, either as a whole or on a particular topic, has gone on for too long, parties should have that faith in him because they have chosen him or her for that matter. Similarly, at final hearing, if he's understood the point, the arbitrator should not remain passive and allow a counsel to just keep arguing. He has to tell the lawyer that enough, I've heard, I've understood. Just by you arguing it over and over again for the next 20 minutes more, I'm not going to change, or as in the point is not going to become clearer. Whatever I've had to grasp from that point, I've understood. So therefore, according to me, an arbitrator is required to be active, not passive. That's the whole idea, because he's been there from the beginning till the end. So even in cross-examination, if he stops or he stops a party, the person should be rest assured that he will remember at final hearing that he had stopped the cross-examination on a topic. That means he was satisfied.
May we have any? Yes, Prachi. Can we have the mic here, please?
Good evening. A slightly different question, but it comes from whatever your lordships have said so far. We see that the arbitration awards are always kept confidential, where all judicial orders are available on a portal. So do we ought not to have these arbitration awards also available on any platform? Because what happens is when we are able to check on the case status with the names of the parties, we see what are the interim orders or final orders, what are the findings against a particular party. In arbitration, and more so when your lordship says that the judicial interference with arbitration awards is very minimal. So these findings will probably help people know what is the order passed in the award. So if your lordship could
Yes,
share.
Prachi, I think you have a point on that because, see, the awards, there's a very limited scope of challenge now to awards. 5%, I would say, really are disturbed. Mostly, the courts allow these awards to go through. Awards become degrees of courts. So therefore, these awards should be known to the public. What is confidential is during the arbitral proceedings, not once the award is passed. That the confidentiality is because it's a private arbitration, it's during that process. But once the award is, there should be some portal where people know because the awards lay down the law as well. So one knows what the law is. That is.
I have a slightly different take on this. I think essentially we must know that an arbitration is basically between two parties. An arbitration, as Booz Allen has said, is a resolution of dispute between two parties and the findings are not in rem. So it is going to bind those parties, correct? Now, there is also the other element of party autonomy, where the parties consciously decide to go for arbitration, knowing that, as Justice Chagla has pointed out, there are confidentiality issues. And therefore, they do not want their disputes in the public domain. Now, as I understand, arbitral awards between two parties are not binding on any other arbitral tribunal or on the court. But yes, at the most, a party can draw some source of, let's say, not a judicial precedent, but what has happened, and how the other arbitration went and what were the conclusions in that, and draw some sort of positive conclusions from that and utilize in his own arbitration. But since it doesn't have any binding effect, and secondly, it is meant to preserve confidentiality, party autonomy, etc., I don't think really parties would like it that their awards are really published and put in public domain. So in that sense, yes, I think Mr. Mehta has some.
There's one more angle. I'm sure no arbitrator would like parties to go through the award and in another matter tell him that you ruled like this on this point and now how can you rule
Yes,
differently?
you're right, yes.
With this, may
So
I
it
now...
doesn't bind the arbitrator, that's what he's trying to.
With this now, may I request the session closed? May I now request our committee members, Mr. Vikram Valavalkar, Siddhi Bhosle, and Akshay Pai, to please come and felicitate the speakers.
Sir, may I ask one question?
Yeah.
Ma'am,
Mr.
may I ask
Valavalkar,
one
may I
question?
just request? Sorry.
One question. As respected sir said that arbitration is a creation of an agreement between the parties. So kindly enlighten us on the point of what are the essential clauses of an agreement on the point of an advocate, so as to frame at the initial
So please
inception.
hold your mic close to your...
Sir, got my question, sir?
Yes.
As a respected,
Yes.
got my, sir, kindly answer me.
No, when these contracts are entered into, the parties have it in mind that there should be an arbitration agreement where they have agreed to go in for arbitration, and the purpose of going in for arbitration is to speeden up the adjudicative process so far as the dispute is concerned. So therefore, the arbitrator cannot travel beyond the agreement. He has to determine the disputes as per the agreement. So therefore, it's necessary when the parties have themselves chosen an arbitrator, that has to be respected, and the arbitrator has to be within the confines of that agreement.
Thank you so much, sir. May I now declare the session closed? I'm sorry, we have another chair waiting for us. May I request Mr. Valavalkar, Ms. Bhosle, and Mr. Pai to please do the honors. Mr. Malavalkar is presenting the memento to Lordship Justice Chagla. Kindly also present the bouquet. Mr. Pai, kindly. Thank you, Justice Dubash, for the insights. Just take it. May I request Ms. Bhosle?
Thank you.
May I now request the volunteers to kindly help the dignitaries to the chair? Thank you so much, sir.